Please.
In this, okay, thank you. In this video, we are going to speak about the Parent Subsidiary Directive of the European Union law. This directive deals with the elimination of economic double taxation arising within a group of companies from cross-border distribution of profits. Economic double taxation refers to the taxation of different taxpayers with respect to the same income. For example, when income earned by a company is taxed both to the corporation and to its shareholders when distributed as a dividend. This directive provides us an exemption from withholding tax in the state of the subsidiary, as well as an obligation for the state of the parent company to either exempt or grant an underlying tax credit. We can see in this example how more or less this directive works. The directive, the Parent Subsidiary Directive, defines its subjective scope and includes a definition of the term company of a member state, which must be met both at the level of the parent company and also at the level of the subsidiary. Article 3 of this directive defines parent company as a company that holds at least a 10% stake in the capital of a company of another member state. Member state, according to what established in this directive, member state may, as an option, make the application of this directive subject to an interrupted holding period requirement of at least 2 years. So this is a possibility that each member state can include or not in its domestic legislation. To understand more or less how the ECJ understand the functioning of this parent subsidiary directive, we can examine, for example, the cases, the joint cases C 218/94 and the followings that we can see in this slide. In this particular case, there was some question concerning the interpretation of Council Directive 94/435. And this one, the previous parent subsidiary directive before the one of 2011. Those questions, the question raised in these facts, have arisen in 3 sets of proceedings brought against the Federal Finance Authority of Germany by 3 different companies incorporated under Netherlands law and each having a holding in a German company. And the problem was related to the taxation of their subsidiaries' profits. So we have 3 Netherlands companies and also a holding or a subsidiary in Germany, in the German state. Article 3.1 of the previous directive of 90s provided that the status of parent company was to be attributed to any company of a member state which had a minimum holding of 25% in the capital of a company of another member state. As we have said before, in the current legislation, the percentage is 10% instead of 25%. Article 3.2 of the former directive gave member states the option of making entitlement to that tax advantage subject to a minimum holding period of 2 for example, 2 years. This was the top possibility, 2 years. So not just having a percentage, a necessary percentage of 25%, but also this directive gave the member states the possibility of establish a period of 2 years for this percentage of shares. Article 5 of this directive provided that profits which a subsidiary distributed to its parent company, as we have said in the previous slide, were to be exempt from withholding tax applied in the source state. This article authorized the Federal Republic of Germany to impose a withholding tax of 5%. In Germany, this directive, this parent subsidiary directive, was transposed by paragraph 44D of the Law on Income Tax. While paragraph 44D1 provided for a reduction of withholding tax to a rate of 5%, that we have said in the previous slide, paragraph 44D2 stated the following conclusion. Parent company, for the purposes of paragraph 44D1, shall be a company which, at the moment when liability to investment income tax appears, can show that it has held directly at least 25% of the share capital of the subsidiary for an interrupted period of at least 12 months. As we have said, the directive establishes the possibility of fixed and period of 2 years, but in this case, the German legislation decided to establish a period of 12 months, so 1 year, just 1 year. In the case that we are studying in this video, Denkavit had since 1973 a direct holding of 20% in the capital of the German company Denkavit. On July 1992, Denkavit's holding in its subsidiary increased to 90%, more or less. So we have a parent company and also a subsidiary. The subsidiary was established in Germany and the parent was established in the Netherlands. And at the beginning, the percentage of property was just 20%, but after an increase in this property, the final amount was 99%. With the idea to making a distribution of its subsidiaries' profit in 1992, Denkavit requested the German tax authority to reduce the withholding tax that should be applied. In its request, Denkavit gave an express undertaking telling that its holding in its subsidiary would continue to be more than 25%, to this 99, for an uninterrupted period of at least 2 years in advance. By its part, the German tax authorities refused to grant the exemption requested on the ground that the 12-month minimum holding period laid down in its domestic legislation had not been complied with in the moment of the request of this exemption of the withholding tax. What about the ECJ decision in this case? The essence of the main point of the question put by the National Court in this preliminary ruling, as we have seen, this is a preliminary ruling created or presented by a national court to the ECJ, to the European Court of Justice. The main point was to decide if a member state may make grant of the advantages provided for the directive, parent subsidiary directive, subject to the condition that at the time when profits are distributed from the subsidiary to the parent company must have held a minimum of 25% of the capital of the subsidiary for a period at least equal to that set by that member state, that in the case of Germany was 12 months. According to Denkabit, the parent company, it follows from the wording of the directive that the minimum period set pursuant to Article 3.2 need not necessarily have expired at the time when the tax advantage is granted, but it can be considered also in advance, so in the future. Maybe in the moment that we are asking for the exemption of the withholding tax, we had not complied with the 2 years or the 12 months in this case request, but we can also have a promise to comply with it in the future. According to what established by the ECJ, member state cannot unilaterally, so just in its domestic context, they cannot introduce restrictive measures such as the requirement that a minimum holding period must already have been completed with the profits in respect of which the tax advantage is sought are distributed. So the conclusion of the ECJ in this important case is that member state, in this case, in our particular case, Germany, cannot make the grant or the application of the tax advantage, in this case, the exemption of the withholding tax, cannot make the application of these tax advantages subject to the condition that at the moment when profits are distributed, when profits are distributed by the subsidiary to the parent company, member state cannot, in its domestic legislation, subject the application of this exemption or this tax benefit to the condition that the parent company should have had a holding in the subsidiary, a 25% holding in the subsidiary during the period laid down in the domestic legislation, 12 months in this case. So long because this period can be observed in the future. So the conclusion of the ECJ is that member states in its domestic legislation cannot prohibit the application of the benefits granted in the directive by its own. Thank you very much for your attention and see you in the next video. Thank you.